This morning I met with a new client of ours here at the Myers Law Group. She had a question as to what type of damages would we be seeking. She had a claim under an area of the law called the Fair Employment and Housing Act. Like most of the laws in California regarding employment, California laws try to make an employee whole, try to address the damages that was caused by the employer's decision that adversely affected the employee. I told the client that as a result of being terminated for what I believe was unlawful conduct, that we'll be asking for a couple things in the lawsuit and then ultimately the jury if we get that far. The first issue that we'll seek is emotional distress. Emotional stress of being terminated, as well as the emotional distress that this employee suffered prior to termination as a result of unlawful harassment. And so we'll ask a jury or we'll make a demand upon the employer that they compensate the employee for the emotional stress for the unlawful harassment that occurred prior to the termination. And then we'll seek emotional distress after the termination. You know, a lot of my employees, there are a lot of the employees that come to me, the clients that come to me, have similar stories, but every story is unique. The uncertainty of having a job going forward is devastating. Wondering how you're going to pay for your mortgage or your rent, how you're going to put food on the table. A lot of my clients have never been terminated. A lot of my clients have never been out of work. A lot of my clients are angry. Angry at the employer that the employer didn't do the right thing. That they're angry for the position that they are now in. They're nervous and they're scared about going forward and having to tell future employers as to what happened and why they're no longer working for a company that they truly enjoyed working for originally. We'll seek emotional distress from a jury for all the emotional stress, both past emotional stress and future emotional stress. In addition to emotional stress, the employee is also entitled to back wages, as well as front wages. The difference between what they would have made at the previous employer that terminated them and what they're currently making. If it took them time to find a job, we'd seek compensation for that period. If the new job that they found pays less or doesn't have as good as benefits as their previous employer, we'll look for those benefits. So that's the second type of benefit, is wages and benefits that we'll be seeking. Some employers are subject to punitive damages. We'll be asking a jury ultimately to award punitive damages for the conduct of the employer, to truly punish the employer, to make sure that they never do that again. Lastly, if you get to trial, we'd also be asking for attorney's fees and costs for bringing the litigation. And so those are the type of damages we'll ultimately be asking for a jury. As we litigate your case, a lot of cases do settle. And the demand that we put out there, or what an attorney will ask for, sort of contemplates all of that. Back wages, front wages, past emotional stress, future emotional distress, punitive damages if the employer is subject to it, and attorney's fees and costs. Now, most cases settle, and it's typically for a lump sum, and that lump sum is to address all of those damages. If you have a question as to what damages you would be entitled to if you brought a lawsuit under the Fair Employment and Housing Act or any other California laws, it's important that you talk to an attorney that can describe or explain those damages to you. If I can answer any questions regarding those damages or any other aspects of California employment law, feel free to give me a call. I'm happy to answer any of those questions.